Hello, everybody. Welcome. My name is Tom Miles. I'm the Dean of the University of Chicago Law School, and it's great to welcome you to today's First Monday Supreme Court preview event. I'm really delighted to welcome you to this event because we've got a terrific group of faculty and because this event is so in keeping with what the University of Chicago is all about, the pursuit of knowledge and ideas and conversation around ideas and knowledge. So as many of you know, our First Monday's lecture is one of our great alumni traditions. Each fall, with the opening of the Supreme Court session approaching, we assemble a group of faculty members to share their insights and their expertise into some of the issues and trends currently facing the court, and often to reflect on previous terms as well. So, of course, we call it First Mondays, even though we're having it on a Wednesday. So welcome to all of our alumni, and especially our alumni of the law school, but we've also joined by alumni from across the university. So welcome, we're delighted you're here. Thank you for attending, and thank you for your ongoing engagement with the university and with the law school. I also want to extend a special welcome to members of the media who are with us. We're delighted you have joined us as well. So we're really fortunate today to have three outstanding members of our faculty to share with us their insights. Each of them is a leading scholar of constitutional law. Each of them is a superb teacher, deeply admired by our students. They are Professors Aziz Huq, Alison LaCroix, and David Strauss. Now, I could go on at length about each of them and their many accomplishments, but you're here to listen to them, not to me. So I will give each one of them a brief introduction, and then we'll jump right into the conversation. Professor Aziz Huq is the Frank and Bernice J. Greenberg Professor of Law. He is an award-winning scholar of U.S. and comparative constitutional law. He has worked on topics such as democratic backsliding. He is also an influential thinker on AI, big data, and their regulation. He is author of the book, How to Save a Constitutional Democracy, with our colleague, Professor Tom Ginsberg, as well as the book, The Collapse of Constitutional Remedies. His most recent book, The Rule of Law, A Short Introduction, is forthcoming this autumn. Professor Huq received his JD from Columbia Law School. He clerked for Judge Robert Sack on the U.S. Court of Appeals for the Second Circuit, and then for Associate Justice Ruth Bader Ginsburg on the Supreme Court. Professor Alison LaCroix is the Robert Newton Reid Professor of Law and Associate Member of the Department of History. Professor LaCroix is a scholar of U.S. legal history and specializes in federalism and 18th and 19th century legal thought. She's the author of numerous articles and multiple books. Her most recent book, The Interbellum Constitution, Union, Commerce, and Slavery in the Age of Federalisms, was just published this past summer by Yale University Press. It examines constitutional law in the period 1815 through 1861. This is a period of important constitutional development that's often been neglected or overlooked. And Professor LaCroix in the book synthesizes the legal, political, and social history to show how the post-founding generations rethought the constitutional vision. Professor LaCroix in 2021 served on the Bipartisan Presidential Commission on the Supreme Court. She received her JD from Yale and a PhD in history from Harvard. Professor David Strauss is the Gerald Ratner Distinguished Service Professor of Law. He is also the faculty director of the Jenner and Block Supreme Court and Appellate Litigation Clinic here at the law school. He is a leading authority on constitutional law and related subjects. He's the author of numerous articles and books, and the influence of his ideas cannot be overstated. He is, for example, the author of the book, The Living Constitution, and co-author of the book, Equality and Democracy, The Enduring Constitutional Legacy of the Warren Court. He is the co-editor of the Supreme Court Review, the most cited journal of constitutional law, which is published right here at the University of Chicago. He has served in a number of top governmental roles, including an assistant to the Solicitor General of the United States and as a special counsel to the Senate Judiciary Committee. Like Professor LaCroix, he was a member of the President's Commission on the Supreme Court in 2021. Somewhere along the way, he has found time to argue 19 cases before the U.S. Supreme Court. He received his law degree from Harvard and was a Marshall Scholar at Magdalen College, Oxford. Again, I could go on at length about our marvelous colleagues, but let me turn the floor over to them. After each one of them provides some remarks about the upcoming term, we'll turn to open the floor to questions. So please submit your Q&As into the Q&A box. And so now I'll turn the program over to Professor Huck.
Thank you so much, Dean Miles. And thanks to everyone attending for their interest in our perspective on the court. So all of you know, last year was a 12 months of extraordinary importance for the court, and in particular, its decisions respecting the operation of the executive branch. At a rough first approximation, the court substantially raised the cost of general regulation by administrative agencies, either by rulemaking or by adjudication, and at the same time lowered the cost of illegal, even insurrectionary action by presidents in its disqualification and immunity decisions. Now, the effects of these rulings have yet to work their way through the legal system and reach our apex court. However, there's every reason to expect that such an effect will be felt in due course. The Loper-Bright ruling, for example, overruling Chevron, was cited some 26 times in the 2 months after it was handed down. In those 26 cases, all Court of Appeals cases, those appellate judges struck down rules in 4 cases, halted regulations in 15 others, and in 3 instances denied government requests for a stay. Only in 4 of the 26 rulings did the government prevail. At the moment, however, the docket is largely dominated by statutory decisions that neither reflect the past year's tectonic shifts nor anticipate new ones. The questions presented include such matters as whether the US Court of Appeals for Veterans Claims appropriately applies a statutory benefit of the doubt rule. This is the stuff of what Thomas Kuhn, in the Structure of Scientific Revolutions, called normal science. It doesn't present the difficulties of teaching or discussing those ideologically infused moments that one might call, after Kuhn, constitutional paradigm shifts. To give a lay of the land, and I will just anticipate that my colleagues will speak about particular cases, I want to do something a little different in terms of a preview, and draw your attention to cases that are not on the docket, that might be on the docket in the coming months. It may have come to some of your attention that this is a presidential election year, although the Washington Post reminded us last night that there are still undecided voters out there. It's really quite astonishing that one can find them. What I want to do is to identify 3 kinds of cases that the court might hear in relation to the incipient presidential election. I have no way of knowing whether any of these cases will arise, whether the factual scenarios necessary for them to emerge will indeed crystallize, but they all strike me as impossible scenarios and therefore worth reflecting upon now. So there are 3 of these. First, there's been a secular trend of increasing election litigation over the last few presidential and off-year cycles. This year, the Democratic National Committee and its allies have filed suit in something like 21 cases. The Republican National Committee and its allies have filed suit in something like 98, 72 cases of which are ongoing. This is substantially higher than in previous election cycles. Nominally, a decision called Purcell, which is a per curiam instructing federal courts not to alter election rules in the immediate run-up to an election. Purcell formally precludes federal court litigation in the run-up to an election, but it's worth noting that the Purcell doctrine is imprecise in the scope of cases or the scope of time that it covers, and doesn't appear to cover those instances in which the Supreme Court disagrees with a lower court ruling, as indeed we saw just a couple of weeks ago with respect to Arizona's proof of citizenship law, a decision in which the court on the shadow docket reversed a Ninth Circuit judgment, at least in part. Also lurking in the background is a residual exception to the court's otherwise categorical rejection of what's called the independent state legislature doctrine in a case called Moore v. Harper, That residual exception in Moore might permit the court to hear challenges to state Supreme Court rulings on the content of state rather than federal law. So there's a class of cases that are out there in terms of sheer litigation volume and doctrinal pathways for these challenges, which would largely be challenges to access to the voting place rules, could emerge and could crystallize in the weeks before an election. A second kind of case concerns a federal statute. Late in 2022, Congress enacted the Electoral Count Reform Act. This was an amendment to the Electoral Count Act of 1887. The 1887 statute has a number of what were perceived at the time as ambiguities or weaknesses that violent insurrectionists on January the 6th, 2021 tried to exploit. The ECRA tries to eliminate those ambiguities, but it creates a new ambiguity all of its own. What is this? The 1887 law created what was called a safe harbor. If you, a state, submit to Congress your slate of presidential electors by a given date, that slate was treated as presumptively conclusive. The statute did not say you had to submit the slate by that date, but it did say that if you did do that, Congress couldn't challenge it. This provision played a role in Bush v. Gore, some of you may recall. The amended Electoral Count Act replaces that provision with a new rule, and the new rule is mandatory. States must submit their slate of electors by a date, now it's one day after the previous deadline, or else. The problem is that the statute does not say what the else is. There is a mandatory deadline without a consequence. Imagine, therefore, a state such as Georgia, where you have a state election board that has, in the past weeks, evinced a certain tendency to invite and foment election-related litigation ex post and ex ante. Resisting certification of a slate of presidential electors that state election board disfavors until after the new statutory deadline. What happens then? Perhaps the Supreme Court would be called in to tell us. Finally, in Trump versus Anderson earlier this year, the court disallowed states, but not the federal government, from disqualifying a presidential candidate as an insurrectionist under Section 3 of the 14th Amendment. The Anderson court, however, does not say, however, that the person at issue in that case, the candidate at issue, is or is not an insurrectionist, and indeed leaves it open for a federal process to make that determination. Recall the Electoral Count Reform Act. One of the provisions carried forward in the Electoral Count Reform Act is a piece of language that was in the 1887 statute that permitted or that required slates of presidential electors to be based on votes that are quote unquote regularly given. There is some scholarship that suggests that phrase, regularly given, means in accordance with federal constitutional as well as statutory and state law. It is at least arguable that that provision in the Electoral Count Reform Act enables or provides a legal basis for a member of Congress in the joint session to object to a presidential candidate on the grounds that they are ineligible under Section 3. The Electoral Count Reform Act has a provision that enables judicial review. And if that provision were invoked, the question of the scope and the force of Section 3 that was formally before the court in Trump v. Anderson may be once more before the court in Senate. Thank you.
Well, I think it's my turn to speak to you all. So thank you very much, Dean Miles, and welcome back to all our graduates and friends in the audience, near and far. It's lovely to see you virtually. So I thought I would talk about three topics that I think all of which were touched on by my colleague, Professor Huck, and I think Professor Strauss will also allude to. One is the ongoing consequences of the presidential immunity decision last July 1st, Trump versus United States. Two, some of the cases involving agencies, administrative agencies, and challenges to the administrative state more broadly, some of which we saw last term, and we can expect some more coming up this term. And then three, a little bit about the court and politics and the court in politics. And here, I think what we can learn from history is especially useful. So I'll talk a little bit about that. So first, the immunity decision. Ongoing consequences are obviously many and sweeping. And as Professor Huck said, we don't really yet know a lot about what will be the law of presidential immunity going forward. But I think one of the main points that we're already seeing in the various cases involving former President Trump is the one element of what I think has to be acknowledged as new law that the Supreme Court made in Trump versus US, which is this category of presumptive immunity, and just trying to figure out what that is. Now, I say, as I look forward to teaching Constitutional Law 1 again later this academic year, what is presumptive immunity is obviously going to be an important point to discuss in class and in terms of the law coming out of that case. And so I think we're already seeing in the New York criminal case, in the DC District Court case involving election interference, this question of what is presumptive immunity and what will that mean in terms of lower courts trying to figure out, trying to sift through both evidence, what evidence is admissible, and also charges. So we know in the DC District Court case, for instance, the prosecutors have submitted a revised indictment. And we will just have to wait and see in many cases what that looks like. But I think one thing the wait and see tells us is the Supreme Court, while it issued this very, very broad opinion, has also increased the workload and the degree to which all of us, I think, will rely on lower court judges to try to sort out the contours of this presumptive immunity. But I think a larger global point that I take away from the immunity decision from the court from July is the way it focuses on what it calls the dangers of intrusion on the authority and functions of the executive branch. And that language really stuck out to me. I thought again about some of the major structural Constitutional Law 1 type cases. The focus on dangers of intrusion on the authority of the executive branch, that really feels like something of a reversal or a shift from what had been the court's general way of dealing with immunity decisions and presidential immunity cases, of which, of course, there aren't many. But going back to the court's 1974 decision in US versus Nixon. So, as is probably familiar to some degree to everybody here, in Nixon, the Watergate case, the court was very focused on the public interest in criminal prosecution for crimes, all alleged crimes committed by all alleged defendants. And there was a sense that there was a systemic interest, a public interest in criminal prosecution and in the proceedings associated with criminal prosecution. In the Trump versus US decision, by contrast, the Supreme Court really downplayed this issue, focusing instead on this intrusion into the executive branch point, which I think also connects in interesting ways to the court's decision in the administrative agency cases, which I'll come to in a minute. One of the things the court said in Trump versus US was the risk of intrusion on the function of the executive branch by a criminal prosecution could be even greater here than in a civil suit for damages, for instance, which is notable because that had previously been one of the few instances in which the court had said, okay, the president doesn't have the president isn't subject to the rule of law. Civil suit for damages is one domain in which the president does have immunity. So you could argue that these two things are in some tension, this public interest in criminal prosecution in the criminal justice system functioning in a sort of equal way across different classes of alleged crimes and defendants. And you could say, okay, on the opposite hand, we have this question about intrusion on the executive branch. Interesting to me, the degree to which the Supreme Court in the Trump case really discounts this kind of public interest idea and instead focuses solely on interference with the executive branch. So one thing I've taken away, and again, it remains to be seen how all of this unfolds in the district court and state courts, is in the immunity decision in Trump versus US, we really have moved from what I think of as islands of immunity in a sea of judicial process or justiciability to a sea of immunity with islands of justiciability. That is the kind of landscape, what's the negative space, what are the islands, what's the sea, has really flipped. And I think in the court's framing of this as being about intrusion on the functions of the executive branch, we see that. And it remains to be seen, of course, how that will unfold again in the various other cases, and also on this very important evidentiary question. Does this immunity even extend to evidence, and what do district courts make of that as they sift through evidentiary questions? Okay, quickly, I'll say a little bit about the administrative agency decisions. There are many, and there were many last term. So 3 issues, I think. One is just the aftermath of the last term and how that relates to upcoming cases. Second, there's a particular domain of interest here, I think, which is cases that have to do with firearms, regulations of firearms. And then 3, maybe a little remark about the role of where these cases are coming from. So all of these issues are likely to come up this term based on cases the court's already agreed to hear. We know, and Professor Huck alluded to, Loper-Bright, SEC versus Jarkissi, the other cases from last term really talking about overruling Chevron deference. But I think at a very broad level of analysis, we could say the court very much has signaled, or not even signaled, has told us that it is interested in overseeing what administrative agencies are doing. Why is it doing this? Well, first, one could say maybe there's a sort of general anti-regulatory view. Certainly, we see that, I think, motivating a lot of plaintiffs to sue. Second, again, we go back to this executive power point, this notion that every time we think about an executive agency, an administrative agency, there's this balancing, I would say, tension, because I don't think it can be really resolved, between independence and control. Control is, can the executive control what the agency is doing? Independence is, maybe we want the agency to be able to function on its own. So one upcoming case that we're going to see that really touches on a lot of these issues is the so-called ghost guns case, Garland versus Vanderstock. A related one, I think I'll just note, is the e-cigarettes case, FDA versus Wages and White Lion Investments. So both these cases, plaintiffs challenging agency actions. In both cases, the plaintiffs brought suit within the Fifth Circuit. Both these cases are coming to the Supreme Court from the Fifth Circuit. I think that's notable, as has been noted and commented on by many people. The Fifth Circuit really as this kind of marketplace for plaintiffs challenging agency activity. But interestingly, I think also there's a way in which sometimes such cases are challenges to agency actions, and there's a sense that they are about statutory construction. They are about agency authority. And sometimes there's an implied they're only or they're just about those issues. Both, though, the e-cigarettes and the ghost guns case, like the agency cases last term, clearly implicate major domains about constitutional law itself, administrative law and constitutional law. So separation of powers. What's the role of agencies in the separation of powers system? This tension between independence and control. And then also the rights questions. We see this, especially the ghost guns case. It's not a Second Amendment case, but the Second Amendment rights ideas and claims are definitely there. So ghost guns are these firearms or kits to make firearms without serial numbers. And in the Vanderstock case, the plaintiffs are challenging an agency, ATF, rule regulating the guns or these kits. And the way the narrow question comes up is the plaintiffs say these kits are not equivalent to firearms covered by the statute under which the ATF has the authority to promulgate this rule. So right away, we're in the level of regulations, but also legislation from Congress. So at one level, it's a sort of, again, statutory interpretation question. When is a ghost gun a firearm? When is it not? But also a separation of powers question. Is agency rulemaking still going to be treated as lawmaking? Or is this another domain in which the court might say, again, with the end of Chevron deference, look, courts actually have a role or need to be involved in second-guessing agencies because agencies themselves might exist in this sort of uncertain space in separation of powers terms. The second point on the agency cases, especially the ghost guns case, this nexus between agency authority and Second Amendment rights claims. We saw this last term in the Cargill case, the bump stocks case. It wasn't a Second Amendment challenge. It was, again, a challenge to agency rules about things and issues adjacent to firearms. But I think it would be a mistake to say the agency cases are over in this bucket, the rights cases, the kind of Second Amendment cases are over there. So I think, again, we should be looking to see in the Ghost Guns case the way that the court, the justices, the oral arguments frame these as agency questions, but also rights questions and constitutional law questions. Then finally, I'll just finish with a note about the history here. And Dean Miles was kind enough to mention my recent book. So I spent a lot of time thinking about history. And I think one of the things that we know, or we should keep in mind, is the mounting pressure on the court today. Ethics rulings, the court as perhaps activist, or the court as supine, the sort of all the criticisms of the court. The court presents itself as above politics, but it has always existed in a political context, and that's been true since the beginning. So I think one of the kind of old chestnuts that we all love, I think we all love, Marbury versus Madison, 1803. There's this sort of kind of old antique principle. The court says we can't let Congress decide the scope of its own power. We can't let the fox guard the hen house. And one way to think about this, so that's the court in 1803, the same questions may apply to the Supreme Court. When is it an umpire of the system? When is it a part of the system? And really going back to the very beginning, to the Marshall Court, and even before, certainly throughout the early 19th century, what I call the interbellum period, Abraham Lincoln running against the Supreme Court in 1860, and then later into the 19th and 20th centuries. The court in politics, of politics, engaged in speaking to politics, has, I think, often been with us. So at a minimum, we shouldn't be afraid to have these conversations or to feel like they are in some way off limits. So I will end there, and I will now turn the proceedings over to Professor Strauss.
Thank you, Professor LaCroix. Thanks, Dean Miles, for the introduction, and thanks to all of you for joining us. I thought I'd talk about a couple of cases, specific cases that are relatively high profile and also have some odd things about them, and then some thoughts about general trends of what's going on with the Supreme Court. So the first of two cases that I thought I'd say something about is a case called Glossop against Oklahoma. This is a case involving a criminal defendant who was sentenced to death. He actually has been before the court once before on a question about methods of execution. But this case is really quite unusual. He was not the person who actually carried out the killing, but he was accused of having arranged the killing. And the Oklahoma state authorities, after he was convicted, after he'd been sentenced to death, after he'd been to the Supreme Court once, there was talk about some irregularities in the prosecution. So the Oklahoma state authorities actually conducted an investigation. And they found that in the prosecutor's files was evidence that the key witness against Glossop, the person who carried out the killing, had perjured himself before the trial court. And that this was at least in the prosecutor's files. If they didn't actually know about it, they should have known about it. And of course, for a prosecutor to knowingly to use perjured testimony is the worst kind of due process violation. And even if they didn't know about it, this was exculpatory evidence that under Brady against Maryland should have been disclosed to the defense. So at that point, Glossop was informed of this. He sought to set aside his conviction. Oklahoma's attorney general actually agreed and confessed error and said, yes, this conviction, at least the death sentence, should not stand. We can't sentence someone to death when there's this kind of evidence of irregularity. What's the Oklahoma, I think it's called the Court of Criminal Appeals, it's the highest court of the state for criminal matters, refused to accept the confession of error from the state. And at that point, Glossop went to the U.S. Supreme Court, and that's the posture in which the case is now before the Supreme Court, with both the defendant and the state agreeing the conviction should be set aside. The court appointed a lawyer to defend the judgment below. So it's in this very odd posture. It, of course, raises these inflammatory issues about capital punishment. The other thing going on in the case that some amici have suggested, and one reason I'm mentioning this case is our Supreme Court and Appellate Clinic had some involvement in it in an amicus posture. And one of the things that the amici are saying is, you might think this is extraordinary, someone having exculpatory evidence in the file that the state didn't disclose and sometimes even allowed people to testify falsely about. But the argument in some of the amicus briefs is it's actually not that extraordinary. It actually happens pretty often. And the court should pay attention to that and, if possible, do something about it. So because of this, because the death penalty case, and because it's this very unusual thing where a state, and this is not a state where it's a death penalty shy state where you maybe have a governor who's opposed to the death penalty, the state actually joining with the defendant and saying this is not acceptable, and the state's highest court refusing to accept that. So that's one case that I think will attract some and should attract some attention. The other case I want to mention is quite different, although it is an even more of a culture wars kind of case. It's called the United States against Germeti. This is a case in which the issue is the constitutionality of some laws of the state of Tennessee that forbid certain kinds of gender-affirming care for minors. You'll notice the caption, United States against Germeti. The United States was actually one of the plaintiffs challenging the constitutionality of this Tennessee law. There's a provision in the Civil Rights Act that allows the United States government to bring an equal protection challenge against states. It was probably there to allow the United States in the days of the Civil Rights Revolution to raise school segregation claims, but it applies to equal protection claims. So there are two sets of plaintiffs, private parents and their children who want gender-affirming care, and the United States. And the United States' principle, though not only argument, is this is sex discrimination. There was a case a couple of years ago, you might remember, called Bostock, that held that discrimination against transgender individuals is a violation of Title VII because it's sex discrimination. The United States says the same principles apply here. And in fact, the United States says it's even worse because if you look at the reasons Tennessee gave for this law, it included things like people should appreciate their sex. So it was really a sort of overt endorsement of various kinds of rigid sex roles, says the United States. And that's exactly the kind of thing that the Supreme Court's precedents in the area of sex discrimination do not allow. That's the argument. The United States also argues it's discrimination against transgender individuals, and that should get some kind of heightened scrutiny. That shouldn't just be treated like an ordinary law. So those are the arguments that are being made in that case by the United States, and it has potential to be a very important and high-profile case. So those are the two things that I think, if you think of cases that aren't in any of the usual categories but might really attract a lot of attention, those are they. I also thought maybe I'd mention two trends, one of which Professor LaCroix just talked about and Professor Huck also mentioned. That is the hostility to the administrative state. This is not news. It's been going on for quite a while. Several of the justices are overtly skeptical about the foundations of the administrative state and administrative agencies. That shows through in a variety of ways. It was a big theme last term for the reasons that Professor LaCroix mentioned. And then there are these cases this term where the theme will be picked up again. And I think we can expect to see that on a going forward basis, both kind of explicit limits on the power of administrative agencies and also generally skepticism about the actions of administrative agencies and whether they have authority under their respective organic statutes to do what they're trying to do. The other theme, which hasn't gotten a ton of attention, although it has gotten some, is what, if you're going to be tendentious, you could call solicitude for white-collar criminals. There has been a series of cases going back now quite a long time, at least a decade, in which the court interpreted statutes outlawing various kinds of corruption, for example, especially by public officials, interpreted them in a way that was quite narrow and narrowed the scope of what public officials could be, or sometimes private individuals, could be convicted for under these statutes. There were two cases in particular last term, one of which a case called Snyder, that held that an anti-corruption statute, in order to prove a violation of the anti-corruption statute, the government had to show, and this isn't quite what it said. I'm being a little sloppy about this. Had to show quid pro quo. It could not just show a gratuity. That is to say, it was not enough that the public official did something and after the fact, as a reward for doing that, got a payment. That wasn't good enough to violate the statute. You have to show that it was an anticipation of the action rather than a reward. Not an obvious construction of the statute. There was a vigorous dissent. But that's the kind of thing we've seen, and seen it in several contexts. The sort of, if you were to say, well, there is sort of, if you were trying to defend this, I think you defend it in two ways. I actually think it's not a salutary trend, but you could defend it in two ways. One is sometimes these cases do have First Amendment overtones because public officials are doing things and people want to show their support for the public officials. And so there's a concern that this could be used to criminalize that kind of action, which, if not protected by the First Amendment, is First Amendment adjacent. The other observation, which is kind of sort of defensive, it is something that I haven't read Justice Gorsuch's new book, but I've read enough about it to know the arguments, and they also have shown up in some of these opinions, that a lot of these crimes are, there's overcriminalization, and if there's not overcriminalization, the sentences are certainly too severe. So that the Congress has kind of gone too far in punishing these crimes, and that's not a good thing. Now, of course, whether that's the court's job to correct that or not is a separate matter, and there have been some vigorous dissents about that in previous years. There was a terrific, I think, dissent by Justice Kagan in a case from quite a while ago, maybe 7-8 years ago, in which she said, look, what you in the majority are doing is just inconsistent with the statute. You just can't read the statute the way you're reading it. But I understand why you're doing it, because this kind of penalty for that crime really seems too severe. But that's not our job. So that sort of thing, I think, is going on as a second trend, in addition to the hostility to the administrative state. And they're a little bit adjacent. I mean, after all, prosecutors are part of the administrative state, and the idea that the government is going too far in keeping people from doing things they ought to be able to do is a theme that unites these two. Then one final observation, which grows out of some of the things that both Professor Huck and Professor LaCroix said, and it's really mostly about the Trump cases, and in particular the presidential immunity case, but, well, really also the other Trump case, the case about whether he should be disqualified from being on the ballot. And that is this. In 1974, the Supreme Court decided the United States against Nixon, which Professor LaCroix mentioned, where the issue was, it was the so-called White House tapes case. The issue was whether tape recordings of conversations in the Oval Office could be admitted in criminal prosecutions over a claim by then President Nixon that these were privileged. These are the most sensitive kinds of conversations taking place inside the executive branch of the federal government, and they should not be put on the public record. And the Supreme Court rejected that argument without dissent. One of the justices, Justice Rehnquist, recused, but the other 8 were united. The opinion was written by Chief Justice Berger, who was a Nixon appointee, and it led in very short course to Nixon's resignation when it turned out that some of these tapes were highly incriminating. So I really want to contrast that, what the Supreme Court did in that case, which was, if anything, even more sensitive than the Trump cases, with the current court. So in Trump against Anderson, the case about disqualification, you had this situation in which the court, basically everybody on the court agreed that Colorado, the state involved, should not be the one who decides whether Trump is on the ballot. But even though they agreed about that, they couldn't write a unanimous opinion. They couldn't even get 9 votes for the same outcome. The court splintered and got a very vigorous dissent. And I think a very sharp contrast to the United States against Nixon, where, as controversial as it was, even though there were people on the court who were identified with President Nixon's political party, they came up with a unanimous opinion. As far as the immunity case that Professor LaCroix mentioned, a similar kind of thing. Now, of course, there was actually disagreement on the merits there. But one notable thing about the United States against Nixon is that while they said those tapes are not privileged, they also established an executive privilege for confidential presidential communications. It just said that in this case, that privilege, in that case, the privilege was overcome because the interest in a criminal prosecution, as Professor LaCroix mentioned. That part of the United States against Nixon that establishes an executive privilege has survived. It's invoked all the time by the executive branch, generally accepted not only by courts, but by Congress. So even though they ruled against Nixon on the particulars, they established a principle that has been quite robust. And if you think about it, that's a pretty impressive performance by the Supreme Court. Decide the particular case in a way that it needed to be decided, but also to set out a principle that has stood up for half a century. And contrast that with what they did in the two Trump cases, especially the sort of notable thing about the disqualification case that they all kind of agreed on the outcome, but still couldn't bridge the gap. And only couldn't bridge the gap, but there was sort of sharp language in some of the dissents. And in the immunity case, where, as Professor LaCroix was saying, exactly what they held there is in many respects up for grabs. And we'll have to wait a while to figure out exactly the scope of this presidential immunity. So I think that is really not a good indication about where the court is these days, that especially contrasted to a time which was at least as turbulent and difficult as our time in the Watergate scandal. And when there were also political divisions on the court, also political divisions in the country, they managed to pull themselves together and kind of write a pretty good opinion. And here, without a dissent, and here they could not do that. And I think that is really, I would say, a troubling sign about where the Supreme Court is these days. And I think now my job is to turn it over to Professor Miles, where he vicariously gets to call on us on your behalfs.
Well, thank you so much, Aziz, Alison, and David. That was really tremendously interesting and insightful. So I do have the delightful but somewhat challenging task to corral the various questions which have been submitted, some in advance, and thank you for those, and some that are being submitted live. And I encourage all of our participants to continue to submit Q&As. And so I'm going to try to group them as much as I can so we can get through as many of them as possible. So we do a number of questions about the administrative state decisions. And so let me group some of them together and then invite the panel to respond to any parts of these that you would care to. So there have been some questions about what does the Luper-Bright decision mean for Skidmore deference in the future. One person has asked whether it would be possible to overturn Luper-Bright and to restore Chevron deference by statute. Could Congress do that? And then we have a number of questions which are about, are there particular, I'll recast this a little bit, are there particular areas of administrative law or law that pertains to particular areas governed by the administrative state that are likely to be disproportionately affected? So some questions about, are there particular implications for the SEC and, its regulations? Are there particular implications for tax law? So I invite the panel to kind of respond to any of that sort of cluster of questions kind of around the administrative state decisions.
Well, I'm supposed to teach, and my dean is making me teach administrative law this fall because he's a big meanie. So let me take the first crack at that, although and then Alison can correct all the mistakes I make. So as far as sort of the implications of Loper-Bright and the overruling of Chevron, whether Congress can reverse it, I mean, yes, the answer to the question whether Congress can change it is yes. Congress could. It would be tricky to draft the statute, but this is within Congress's domain to prescribe the degree of deference. There is arguably an Article 3 limit on that Congress could not put administrative agencies entirely in charge of deciding the law. But as far as a certain degree of deference, at least to certain kinds of decisions, Congress could go, I think, pretty far. Not, restoring Chevron depends on how far you think Chevron went, but Congress could certainly do something on that front. With, as I said, an Article 3 boundary. As far as the significance of it, and this I'm not at all sure about, and I might just be completely wrong, I'm not sure it'll make that much difference, the overruling of Chevron, whether local bread will make that much difference. There is an old administrative law decision called Universal Camera. It has to do with review of facts in an adjudication, and the substandard is substantial evidence. And Justice Frankfurter wrote an opinion talking about how the substantial evidence test really establishes a mood rather than something you can rigorously apply. And I think Chevron kind of conveyed a mood to lower courts. And Loper-Bright, of course, conveys a different mood, but I think that's the realm in which you're operating. So if you think, you're a district court judge or a court of appeals judge, you've got some complicated statute, you're not sure you understand it. The agency has done something that looks pretty sensible and looks like they played it straight. And the agency obviously knows more about the statute than you do. And you're just trying to do the right thing. You don't have an agenda. The tendency for that judge will be to say to the clerk, let's go with the agency. It's not obviously wrong. I don't quite see what's going on. Let's go with the agency. Now, with Chevron on the books, that's a very easy tendency to give into. Now that Chevron's been overruled, judges, I think, will be a little more reluctant to do that. But I think that's the domain in which we're operating. So to that extent, I think my guess would be it's that there is less to Loper-Bright than meets the eye.
I'll just chime in to add one or maybe two thoughts. I think I second everything David said. Also, I think there's sort of two sides of this question as well. So you could say, if on the sort of supply side, maybe like different agencies might have different views about this, different relationships with courts, how they think about, do they want to have things challenged? Do they not? And also, I think, courts are still perfectly free to say, we decide to defer to the agency expertise, et cetera, all the things that were just mentioned. We're just not sort of commanded by Chevron. Now, maybe that Chevron point gave cover to courts. But I think, and then another sort of piece of the dimension or another dimension of the puzzle is, if the end of Chevron with Loper-Bright emboldens potential plaintiffs to challenge agency action, which seems like it's clearly already happening, then dynamically we might expect to see agencies become more risk averse, cautious about rulemaking again, because they don't want to constantly have to be hauled into court. Or maybe not, right? Maybe they think, no, we want to look like we're aggressive on this particular issue. So it seems like a very complex dynamic that's not only about sort of the agency and Congress.
Great, thank you both very much. We've got a number of questions that are less about particular cases and a little bit more about, I guess, what I'll call the sort of work of the court. So let me group these in a couple of ways. There have been a number of questions about, of course, I think it's widely known the court has granted cert in fewer cases than it used to in past decades. Questions about, is that likely to continue? Questions also about the use of the shadow docket, which has received some public discussion in recent years, and questions about, is that good, is that bad? And then I think a parallel set of questions that I'll just group here to try to corral everything and invite you all to respond to whatever pieces of this you would like to, that are about the sort of methodology of the court. And in particular, is there less respect for precedent than in the past? Some very specific questions about how does one teach that in this moment when it seems that there's less respect for precedent? And then also some questions about, and I think here, particularly thinking of the immunity decision, a number of members of the court are purported to be originalists, or at least willing to engage in that methodology, but then sometimes don't seem to deploy that methodology. And so how do we think about the court's use of that methodology and the court's use of or seemingly less reliance on precedent than in the past. So partly about the workflow of the court and the methodology of the court. A number of questions around that. So invite any responses or thoughts on those dimensions.
I can jump in with one quick thought on both. On the workflow of the court, the volume both of the shadow docket and the merits docket are functions of, in effect, the incentives of usually 4, sometimes 5 justices. And the incentives that they work under are in part a function of the nature of political conflicts that can be transformed into statutory or constitutional conflicts, which, as Tocqueville, first of all, said, might be almost the entire universe of such political conflicts, and the felt constraints that the justices work under. I think that there's no reason to expect the universe of disputes that are political that can be transformed into legal to change in the near term, whether there's a Harris or a Trump presidency. If there's a Trump presidency, you would expect to see challenges brought by both private parties and states to various deregulatory and other policies. And there is, I think, again, regardless of the presidential election, not really any configuration of national political forces acting through the elected branches that could effectively alter the justices' incentives. And I think that we see that in the relative indifference to President Biden's recent remarks on an ethics code and term limits, that the indifference is driven by the sense that the gulf between the proposal and the political reality is one that is too large to be bridged anytime soon. And then on the question of of the court's methodology, one way to think about that is that the court has had a reasonably stable methodology throughout. That methodology involves a blend of looking to some understanding or some sense of what was anticipated or understood when a constitutional text was enacted, some sense of how the quiddities of politics or society have changed the understandings or the meanings or the practices, whether governmental or social, that have emerged under that provision, and then some further sense of what expectations there are baked into, be it judicial precedent or the practices of government or otherwise that people have, and that through some process of casuistic reasoning, the court knits these 3 sources together and reaches some kind of judgment. And in that light, even decisions that I suspect that the 3 of us would resist in terms of their conclusions, such as Trump versus United States, don't seem methodologically all that distinct, as opposed to perhaps being arguable with respect to the particular ways in which methods are applied from earlier generations of judicial decisions. What I do think is distinctive and perhaps eyebrow-raising is a claim that is occasionally made of methodological monopoly, of the illegitimacy of certain kinds of methods that are seen on the court. And I'll end with one example of this that struck me quite forcefully this last term. Justice Kavanaugh issued concurring opinion in a Second Amendment decision called Rahimi, which involved firearm possession by people who commit spousal or familial violence, in which he decried consequentialist reasoning, looking, in other words, to the outcomes or effects of an opinion as a way of judging whether that opinion is legally correct or not. And Justice Kavanaugh joined the opinion that Professor LaCroix described in the Trump immunity case, which is, on almost all of its important points, utterly consequentialist. I think one can draw one's own conclusions from that.
I'll add on the Rahimi case that Professor Huck just mentioned. Very interesting. Another of this connection, this set of firearms-related cases. That was a Second Amendment challenge, not an administrative agency challenge. But it was interesting, very, very much to me as a historian looking at the court doing originalism in that case, because the court says, you can see them sort of struggling in some ways, wanting to uphold the regulation, the act of Congress. But then there's this question of how far are they going to go with a certain species of originalism and Second Amendment case law. And the majority says, well, the law at issue here is, and the phrase they use is relevantly similar to older laws. Now, here they're trying to have the, quote, history and tradition standard from an earlier Second Amendment case still be faithful to that, but then to sort of draw like a broader boundary around how the analogy has to fit. And we get this language of it's relevantly similar to old laws. So one view would be the court, at least those justices, modulating their originalism. And how should people feel about that, right? Whether they themselves are originalists or critics. I think that's another wait and see. But I think, to me, it shows some of the real problems with originalism. How do you decide what is the relevantly similar test? What does that mean? On top of a history and tradition, I don't call it a test. I think some people do. It's more of a standard, if that. And so they're getting further away from what is supposed to be, I think, a kind of supposedly clear-cut exercise. So I think we're seeing cracks in that facade in the Rahimi case.
Let me just second some of the things Alison just said, and Aziz also. I actually go further. I think originalism is not a thing. I don't think it is a coherent and plausible approach to the Constitution. If you try to make it coherent, it's no longer plausible. If you try to make it plausible, it turns into just kind of a rhetorical cover for things. And the Second Amendment cases, which purport to be originalist, I think have illustrated that. I mean, they've come up as Professor LaCroix was just suggesting, with this extremely ill-defined doctrine that, I mean, if I were to be nasty about it, I would say that the case that establishes this doctrine, such as it is, Bruin, a case from New York State, I mean, they talk about how you have to reason by analogy, and you're looking for analogies, but not historical twins. And as Alison said, sort of relevantly similar things, and it sort of sounds like a dorm room conversation among a bunch of freshmen who've just taken their first philosophy class. I mean, it is really, for something that's supposed to provide real guidance to lower courts and legislatures, it is really I'd say kind of embarrassing, really. Now, that doesn't mean you can't make something coherent of it, but if you're going to do that, you're going to do the kinds of things that, as Aziz just said, they pretend they're not doing by looking at the actual consequences of various rules. And you're going to look at precedent and what's been done, both judicial precedent and kind of past practices. And I think that is what's really going on, not kind of skipping over the intervening 200 plus years and saying, well, what did they decide in the framing? But, very sensibly trying to take advantage of the lessons of the last couple hundred years of experience. I think they actually end up doing that, even if they occasionally put it in originalist terms, and even if the supposed commitment to originalism distorts what they're doing.
Wow. Well, thank you very much, Professors Huck, LaCroix, and Strauss. Like a true University of Chicago style event, no lack of incredible insights and strong opinions. And thank you very much. I feel like we've just scratched the surface. We had a large number of questions. We didn't even get to the First Amendment. We didn't get to the Fourth Amendment. We didn't get to equal protection. There was so much more here. We could go on for hours, but unfortunately, we have reached our time limit. I do want to thank our panelists, Professors Huck, LaCroix, and Strauss. Thank you very much for joining us and sharing your insights with us. I want to thank all of our alumni from the law school and across the whole university for joining us. And I encourage you to watch for announcements about future online and remote and in-person events. We so grateful for your engagement with us and your desire to stay in touch with the law school and with our faculty colleagues. So thank you very much for joining us. I invite members of the media to stay on the Zoom for an opportunity to engage directly with our panelists. Thank you, everybody, for joining us today. Happy First Monday.